Today we are going to discuss an unusual but valid way to get your green card. It's called Special Immigrant Juvenile Status, or just Special Immigrant Juvenile, SIJ for short, SIJ. I'm going to tell you how you get this type of visa.
Calificas para ser legal, ¿quieres saber? Solo llama al abogado Andrés Mejer.
You've probably heard my story, but in case you haven't, I want to share it to you because it might help you understand why we treat clients the way that we do. My family and I immigrated to the US in the 80s. When we came here with visas, we got an attorney who said they could help us become green card holders and then citizens. That attorney took our money. They did absolutely nothing, and my parents had to drive all the way to New York several times over the course of 2 or 3 years, almost 5 times, each time bringing money. Our visas expired, and for a time we lived without legal status in the US. This negatively impacted my family for years. As an adult, I worked hard to become a US citizen and an attorney to help people like my family. I'm determined that my office does everything it can for every person we have the privilege of serving, as if I'm helping my own family. I now have a very big family. We have helped over 3,828 people about the legal process, and we've educated thousands more about what they qualify for. How do you get your green card through the SIJ process? There are very specific conditions you must meet in order to qualify for a SIJ status. This could be a very good option for those that qualify. There are 3 separate steps, and we're going to go over each one in detail. First, you have to get a court order from a juvenile court that you have been abused, abandoned, or neglected by at least one of your parents, and other requirements. This is an unusual situation because immigration is federal law, but there is no federal court that is tasked with making decisions for minors. So the SIJ statute gives state court judges the authority to make those decisions. Not all judges have encountered this. Not all judges are familiar with this process. The type of court varies by state. In New Jersey, it's the Superior Court Family Division in the Chancery section that decides the dependency or custody and care of juveniles. It's, again, based on state law. So New York, California, Texas, New Jersey, Pennsylvania, each may have different definitions for what is abandoned, abused, or neglected. I'm going to try to talk about in general terms. Once you get that predicate order, you then have to apply to USCIS for SIJ status using Form I-360. Lastly, you apply for your green card using Form I-485. We're going to talk in more detail about each one of those 3. Let's first talk about the juvenile court order. If you are over 18 years of age today and under 21, you need to be careful. Some state courts only have authority to make decisions for juveniles under 18. In New Jersey, it's not age specific. You could do it up until you turn 21 years of age. There are many 18-year-olds who are in college and still dependent on their parents. But again, that's not true in every state. Even in New Jersey, there has been litigation against USCIS on this exact issue. July 3rd, 2019, there was a decision by District Court Judge Madeline Cox-Arleo. She granted a preliminary injunction to prevent USCIS from denying SIJ petitions based on the fact the family court lacked jurisdiction to make child welfare findings for petitions 18 to 21. Let me unpack that. USCIS, immigration was trying to say, hey, state doesn't have jurisdiction, doesn't have authority to make a decision on an adult. An adult they define as 18. The judge said that is not true. It is not automatic. It is not a blanket denial. The Superior Court of New Jersey has authority to make decisions for those who are between 18 and 21. Immigration tried to say no, that was not the case, and the district court judge said, you are prevented immigration from saying that, period, end of story. So even in New Jersey, that's happened. Now I know there was a similar decision in New York, I believe also in Maryland. Check your state. So let's assume the judge, you are under 18 or 21, and you are now looking to make the decision, the predicate state court decision by the judge. Let's talk about the 5 things that you will need to prove. First, you must be under 21 years old, must be under 21. This is proven by your testimony and corroborated by your birth certificate or passport. Second, you can't be married. Now, if you were married at a younger age and your spouse died, or it was annulled, or you were divorced, you can still apply as long as you're under 21. And again, this is usually proven by simple testimony. If you were married, well, then you need a divorce decree or a death certificate or an annulment. You're going to have some legal document terminating that relationship. Third, you must have been declared dependent on the juvenile court. This means the family court takes jurisdiction over you. If you turn 21 while your SIJ application is processing, that is okay. You just can't be 21 before the judge makes the decision. Again, this is typically proven through testimony. Someone, parent, relative, or friend, or an agency is filing for your custody. That person or agency will testify that they provide for your needs. For example, if you are 14 years of age and you're in school, the person or agency applying for custody will testify they provide for your room and board. Fourth, reunification with one or both of your parents is not possible because of abuse, neglect, abandonment, or other circumstances based on state law. So let's take a step back. This is now the fourth requirement. 1, you're under 21. 2, you're not married. 3, you're dependent on someone. 4, you can't be reunited with one or both parents because of one of these. Let's talk about abandonment. It's usually the easiest to prove. The parents don't provide any of your needs and hasn't cared for you or even contacted you. Now, in some states, death can be considered abandonment because it is like abandonment since it leaves the child without support. But check your state before making this argument. Even if you can make this argument in your state, your case would be stronger if you make the argument for abuse or abandonment before the parent died. When I had a case like this, dad died of cancer, but dad was diagnosed with cancer 6 months before, and he locked himself up in his room. He didn't eat, did nothing to help himself or his family, and then ultimately died. We got a judge to determine that father abandoned his family before he died. Abuse. It can be physical or it can be verbal. Physical abuse can be easier and proven through testimony of what you suffered. For example, parent frequently beat you with a belt and his hands when under the influence of alcohol. It's usually dad, but doesn't have to be. Physical abuse is often coupled with emotional abuse through profane or inappropriate language. Emotional abuse without physical abuse is harder to prove and will likely require an expert like a psychologist or a therapist who's going to evaluate you and support your position that what you suffered was due to your parents' emotional abuse. Neglect. Neglect is usually inaction by a parent. For example, mom did nothing to stop father from physically abusing the children. Keep in mind, you must show you can't reunify from at least one of your parents, but you need the judge to decide if reunification is possible for both parents, even if one of your parents is the one requesting the court decision. That's the law based on Supreme Court of New Jersey decision in the past couple of years. The judge makes the factual decisions, it then goes to immigration, and they ultimately decide to approve or deny your SIJ case. Last requirement, 5th, it is not in your best interest to return to your home country. This, again, really varies by countries. Let's review. Under 21, not married, dependent on someone, can't reunify with one or both of your parents for one of those reasons. And 5th, it's not in your interest to go back. Generally, you should provide evidence of the conditions in your home country and region where you live. For example, there are organizations that print yearly or semi-yearly reports on the conditions, like country reports on human practices, the Central Intelligence Agency, the CIA's World Factbook, Amnesty International, Freedom House, Human Rights Watch. Each one of those organizations provides a yearly or biannual report on most countries. Now you take that information and you compare that to life and opportunities that you have now in the U.S. For example, in Guatemala, you might have had to work and you couldn't go to school. You didn't always have food to eat each day. In the U.S., you can go to school and you lunch in school every day. If the judge doesn't make these findings with details, then you can't go to the next step. What's the next step? I'm glad you asked. You gotta fill out Form I-360. It's the petition for Special Immigrant Juvenile. You will need to fill out the form. You need to be very careful because Form I-360 is also used for widowers, VAWA applicants, and special immigrants like religious workers and physicians. So there are many portions of the form that don't apply to you. Make sure you don't leave any questions blank. Instead, put an N\A for not applicable. You will have to attach proof that you're under 21 again. This is simple: birth certificate, passport. You absolutely must file the petition before you turn 21, otherwise you're just not eligible. If you are in custody of the U.S. Department of Health and Human Services, you will need written consent from the department. To date, none of my clients have needed this, but then none of them are in custody with the department when they meet with me or when their family meets with me. Often they are released to their family first, then their family comes to me, and that's when we decide SIJ or asylum or something else is the best option for them. You will also attach the judge's order. Make sure the order includes a detailed explanation for why the finding was made. For example, the order shouldn't just say, George was abandoned by his father. It should say, George was abandoned by his father at 5 years of age because his father's had no contact with George for the last 10 years and he doesn't provide for his needs. The because is incredibly important and will help you avoid problems at the I-360 stage. The I-360 grants you SIJ status, but it is not an end in and of itself. Being classified as a special immigrant juvenile allows you to apply to become a green card holder when a visa becomes available. What's the next step, you ask? File for your green card. Third step is to apply for your green card using Form I-485. Now, once your I-360 is approved, that's your SIJ application, you're going to have to wait for a visa to become available to finally file for your green card by filing Form I-485. If an immigrant visa is immediately available to you, you can file both at the same time. So what are we talking about? First, we get a decision by the judge that meets all the requirements. Once we have that decision, we submit it to immigration with Form I-360 saying, hey, here's what was decided, here's why it was decided, please grant me SIJ status. Once that's approved, you file for your green card. When you file for your I-360, you can check if there's a visa immediately available. If so, you file for both the green card and SIJ status at the same time. Immigration is not going to review your I-45 until your I-360 is approved either way. If not, you file for your I-360. Once that's approved, once the visa becomes available, you then file for the I-45. Now, you're going to have to check the visa bulletin. SIJ status is the fourth preference on the employment side. It's called EB4. It's an immigrant visa category on the visa bulletin that's maintained by the Department of State. I have previously explained how the visa bulletin works. Look before for the video explaining it, or you can request a copy of my book. I have a chapter that talks about it there too. I recommend you consult with a qualified immigration attorney to determine which is your best situation, when to apply. Apply for both at the same time or apply for just a green card. To be honest, it's very difficult to get this far without an attorney, but if you did, hey, kudos to you. Your age does not matter when you file for your I-485. You can apply before you turn 21, when you turn 21, or years later. As long as you got the predicate order and you filed the I-360 before you turn 21, your age when you file the I-45 doesn't matter. Where you file for I-45 really does matter, whether you're in removal proceedings or not. If you aren't in removal proceedings, you file the form with immigration. If you are in removal, you're going to file the I-360. Once that is approved, you're going to file a motion to terminate proceedings in front of the judge. And you're going to ask the judge to remand the matter to USCIS so that they can adjudicate the I-45 petition. If the judge grants your motion, then you file with immigration. If the judge denies your motion, then you're going to file Form I-485 with the court, and you're likely going to have a trial in front of the judge on that application. It's still a whole lot better than the asylum scenario because you already got a trial on the family court side, you already got immigration to agree that you have SIJ status. Now you're moving to get your green card, and honestly, there generally isn't a reason to have a trial in front of the judge. If it is, it's a relatively simple one in comparison to like an asylum, for example. Once you file Form I-45, you are going to receive a biometrics appointment to get your fingerprints and picture taken by immigration. If you haven't submitted a medical exam or it's expired, you're going to need to submit a new one through Form I-693. If needed, USCIS may request more information or schedule an interview with an immigration officer. It really depends on your local jurisdiction. In New Jersey, it is very rare. None of my clients so far have been interviewed for the Form I-45, but I imagine that's going to happen. If Trump wins re-election, there's no question that they're going to require those interviews as well, just to slow down the process and to waste more time. If your green card application is approved, you will receive a notice saying, hey, congratulations, you're approved. The date on the notice is the date you become a lawful permanent resident or a green card holder. If your green card application is denied, you're going to receive the notice explaining why. You cannot appeal that decision, but you can file a motion to reconsider or a motion to reopen with additional documentation, or you can renew your petition in immigration court. So if your I-45 is denied and you're not in removal proceedings, you likely will be placed in removal proceedings. If you're already in removal proceedings, the judge is just then going to decide at that point. If you need to file either a motion or you get placed in removal proceedings, we highly recommend you hire an immigration attorney. If you haven't gotten one at this point, you need one now, because to be successful, you're going to require a legal argument, and your chance of success is a lot better with a good attorney. Just that simple.